I think Michael did a good job of kind of laying out some of the key issues. So I'll go in a little bit different direction. Michael talked about the fact that we have two laws right now. We've got the old common law, and then we've got the statute that was passed in originally in early 2011, and then repassed in May of 2011 because of some problems with the effective date and the constitutional amendment. So we're in this unique situation where for probably at least another 5, maybe 10, depending on how long people stick around, maybe longer than that, where you have two different legal regimes we're dealing with. I got the reputation when the new statute was being debated and discussed as being opposed to it, and that really wasn't accurate in the sense that I was out there talking about how I had concerns about the statute, not because I didn't think Georgia law needed to be fixed. The old common law, I think, had a lot of flaws and a lot of problems. But I had an opportunity to speak early on in the process, and I really wasn't asked to speak on one side or the other. I started doing some research, and what I found was that there are all kinds of academic studies that conclude that greater enforcement of non-competes and restrictive covenants is not good for economic development. It's not good for innovation. It hinders employee mobility, which is a driver of innovation. It depresses wages. There are a lot of negative things that come along with greater enforcement of non-competes. And so when I started looking, I said, well, surely there's got to be some academic studies and other things out there. There's got to be some things that indicate that greater enforcement of non-competes is good, because why else would we be having this discussion? But the problem was I couldn't find any. And I had the opportunity, as Michael did, to go down and testify before the study committee at the General Assembly that was looking at kind of crafting and passing this legislation. And Kevin Levitas was the chair. He was the proponent of the bill. And I testified for over an hour, and he just grilled me on all of the problems with the existing common law. And what I kept trying to impress on him was, again, that it wasn't that our law didn't need to be fixed. It was that I didn't feel like the General Assembly had done its homework in determining whether this was good policy. I mean, you can look at California, and there's a lot of issues in California, but having non-competes be illegal in California has not hindered at all the economic development in Silicon Valley and the rest of the state. So just this kind of knee-jerk idea that, well, because the majority of states enforce non-competes more liberally than Georgia does, that we should fall in line with them, to me seemed like just not a good explanation for why we were going down this path. And so maybe we're going to be a grand experiment. One of the studies that I found had to do with Michigan. In Michigan, prior to, I think, 1985, non-competes were generally not enforced. And then the law changed, and after that, the law it became much easier to enforce non-competes by employers. And the study showed that there was a significant drop-off in the number of patent applications coming out of Michigan during that time. Now, as all of the studies, that study has a flaw, which is that the U.S. auto industry was also in decline at that time, and that certainly may be an explanation why there were less patent applications coming out of Michigan. But the other study is, there's one that tried to compare, I always forget the name of the highway, I think it's I-78 or I-128 up in Massachusetts, which in the 70s had a very similar number of tech companies to Silicon Valley. And then by the 90s, Silicon Valley had far surpassed what happened in that area of Massachusetts. And this study suggests that because of the free flow of ideas and the employee mobility, Silicon Valley took off, and because in Massachusetts non-competes are liberally enforced, that has hindered the growth of tech companies in that area. Now, Kevin Levitas' response to that was, well, if you had a choice of living in the snow belt of Massachusetts or living in Silicon Valley, where would you go? And like I said, every single one of the studies has some flaws. You can certainly point out other reasons. But to me, I think the fundamental policy issue is one that really hasn't been vetted, hasn't been thought through. We now have this new legal regime, and it is here, so we need to deal with it. And that's really what we're going to spend most of the time talking about. But when Gary mentioned that we could have a few minutes to talk initially, I just wanted to bring that up and get you thinking about whether liberal enforcement of non-competes really is good as public policy and economic policy versus whether it's good or bad if you're representing an employer or an employee in any particular situation. One thing I agree with Michael on clearly is that it is much more expensive now to litigate non-compete cases than it was before. Before, your average middle manager, maybe making $100,000 or $150,000, could hire a lawyer and for $25,000 or $30,000, maybe $40,000, get a declaratory judgment ruling or defend a TRO hearing, because you could just go to the court and say, look, on the face of the covenant, on the face of the document, it's unenforceable as a matter of law. And now that doesn't exist. Now everything is fact-intensive, and the new statute requires an evidentiary hearing. It requires discovery and things that your average individual can't afford. And so, like Michael said, unless the new employer is paying the bill, or unless the individual is somebody that has a much higher income level, it's very difficult for them to litigate these issues. And then one last thing was, one of the proponents of the bill talked about the predictability. And while the old Georgia law clearly was not perfect, it was fairly predictable. In my view, if you knew what you were doing, you could craft covenants that were enforceable under the old law very easily. And under the new law, you can certainly craft covenants that are enforceable, but in trying to advise a client, whether you're representing an employer or an employee, on what the result is going to be if you go into court, it's virtually impossible, because under the new law, it is very judge-specific, it's very fact-specific, and we, at least right now, don't have any appellate court decisions from the Georgia courts with respect to how and in what manner the courts can modify or blue pencil the agreements. So you really have no idea what you're going to get when you go into court. I think the only thing you can say is, if you're representing the employer, it's likely you're going to get something, which under the old law you may not have. But what the extent of that is and how much that's really going to slow down the former employee is yet to be seen.